Hun.
Da.
Ting. Mock. Chur.
Yep.
Roll. Okay, on that note, we're going to look at the different roles in a trial case, and then we're going to look at the important rules for a jury, and then lastly, we're going to look at the different steps in a mock trial. Okay, so Caleb, please read judge for us.
Okay. Judge. This person helps run the courtroom by serving as a referee to make sure both sides follow the courtroom procedures. This person also answers all questions about the law and issues sentences.
Okay, so again, we watched that video where we talked about this idea that he serves, the sports analogy, the judge serves as a referee between both attorneys. Okay? He or she also answers all questions about the law and issues sentencing. Anybody know what sentencing is? Enzo.
It's like a sentence would be like a year in jail. It's like
Exactly. How much time or what the punishment is. Very good. Okay, Betsy, please read district attorney or prosecutor.
District Attorney, Prosecutor. This is the state attorney who represents the people of the state and attempts to prove the defendant's guilt beyond a reasonable doubt.
Okay, so they're hired by the state, and again, the burden of proof is on them to show the defendant is guilty beyond a reasonable doubt for the crime that was committed. This is only in a criminal case. District attorneys in a criminal as well as a civil case. John, please read.
Defense attorney. This attorney represents the defendant and attempts to prove the defendant's not guilty by showing weaknesses in the prosecution's case.
Good. Okay, witness. This person answers questions posed, meaning asked, and provides truthful and complete answers. So if you're this in the mock trial, as a witness, you need to answer all the questions that are asked, okay? And you also need to be truthful and answer them to the best of your ability. Yes?
But aren't there like some witnesses, like false witnesses, like they be paid to say wrong things?
Well, if they actually do it in a real courtroom, or in this case, in our trial, they're gonna, in our case, they're gonna lose a lot of points because I know the case, I know what should be said, okay? But also, they can get in serious trouble. That's lying under oath. That's known as perjury.
Okay, I was just going to ask, well, what happens if you...
That's like that's a major offense. So they could actually go to court, or they could actually get charged.
How would you figure out?
Yeah.
Different ways. I mean, putting the
In
pieces
this class,
together.
you would know
What
because
happens with that governor who,
He's in jail right now.
well, there's one guy
Awaiting sentence. Or
was saying, no, I didn't do it, no, I didn't do it. Then somebody finally found out he did it. Okay, never mind.
I don't know. Defendant Maya, please read.
This person attempts to show he or she is not guilty. He or she cannot be required to provide evidence that will incriminate himself or herself.
Okay. And that's in the what amendment? Do you guys remember?
Oh, wait, the
fourth.
fifth. Cheating.
Good, fifth. All right, the plaintiff, the person who files a complaint to sue, in a what case?
Civil.
Just a civil case, okay? And then jury member. Each of you will be a juror. This person listens to all the evidence, okay? And then determines the final verdict. So all of you will be listening to the case, and then when you are not presenting your trial, you guys will make the final decision out in the hallway or out in the team room. Okay? Important rules for a jury member, and this is also including for your mock trial. You should not make any judgments until all testimony has been delivered. Okay, everybody know what testimony means? What it means is people saying what happened, like the story, their understanding of what happened. You should not speculate or guess about anything related to the trial. You can only focus in on the evidence. stated in the courtroom. That's very, very important. If you're ever on a jury, the judge will tell you that over and over. Okay? And then do not discuss the trial with anyone outside the classroom.
Not even your mom?
Alright. Questions there? Any questions on the vocab? So this is important terminology you can go back to when you're working on your trial. If you're trying to remember who's this, what's going on. Okay, next. Steps in a mock trial. Okay, the first thing, step 1 is opening of the court. That's when the judge will enter, everybody will rise, the case will be announced, and then the charges will be announced as well. Okay? Yes, Enza?
I have a question for mock trials.
Yep.
Who's going to be the judge?
It's going to be someone from the other group. Or if no one wants to be, it'll be me. Now what the person will have to do though, and we can decide next week, they actually have to read through the case. So there's extra work if you want to be a judge, because you have to know sort of what goes on. Okay? Alright, step 2, opening statement. Both attorneys preview the evidence they will present. They'll say things like, the evidence will show that my client is not guilty, or the evidence will show that the defendant is guilty because, and they'll sort of give an intro, a preview. Okay? Step 3, please read for us. Ethan C.
Direct examination by prosecution /
Alright, speak a little louder, keep reading.
The prosecutors conduct the direct examination of its own witness. At this time, testimony and other evidence prove the prosecution's case will be represented. The purpose of the direct examination is to allow the witness to state the facts in support of the case.
Okay, so think about this. The prosecution's not going to call a witness that's going to hurt their side. At least not intentionally. So they will have they'll know a little bit about what these people are going to say, and they'll say, yes, we're going to choose this person to testify, or if they don't really help your cause, then they're not going to.
But you can't tell them what to say, so you don't know what they're
You can't.
What if someone asks
However,
Can you ask the question?
you will talk to them ahead of time, in the sense of you'll know sort of their statement. You'll sort of know what
You ask them right, if they word right or they're right, you can't ask them that? Oh.
No, it's more of if the person was a witness or they saw something suspicious, or if they didn't see anything suspicious, then they're just going to say that. Okay?
What if the person acts like that in front of the defendant, but when they're on there says something different,
Yeah.
says their real feelings?
Again, they have to
You won't switch it.
say under the oath. They have to they're testifying under oath. So they have to tell the truth. Alright, once the prosecution finishes, the witness finishes, they get cross-examined.
Oh, there's a form of
Okay? Oh, let me step back for a second. It's important to know that both sides should remember that their only function is to ask questions. So attorneys' only function is to ask questions. Okay? Attorneys may not testify or give evidence, okay, and must avoid phrasing questions that may violate this rule. Okay, so you may hear like, no leading questions. You can't ask the leading question. Things like that. Okay? So again, you can't have the attorney's not telling you the story. The witnesses are telling you the story. They're not adding in pieces. Well, this person said this, so this is what happened. They can't do that. They're asking questions. They can try to put it together in the closing statements, but they can't tell the story. The witnesses are doing that.
Can you ask the witness, like, what did you see, like, before?
Yes.
Like,
Yeah.
before, though?
Yes.
Oh.
Yep, we'll do that. Alright, after this, step 4, the prosecution witness is still up there. They're going to be cross-examined. Anybody know what cross-examine means? Okay? Well, it means this. After the prosecutor has completed questioning each witness, the judge then allows the other party to cross-examine the witness. What this means is to clarify or cast doubt upon the testimony of opposing witnesses. So both sides do this, and the purpose is they're trying to find inconsistency in stories, bias, or other damaging facts. So they're trying to hurt the credibility of that witness. Because they're trying to show that their side of the story is correct. Okay. Step 5. Once the prosecution finishes with all their witnesses, direct examination by defense attorney. Okay. So it follows the same step as 3. Cross-examination will take place when the prosecutor can ask questions. So the same procedure as step 4. Any questions so far? Okay. Step 6, closing arguments. This is where a review of the evidence is presented. It should indicate how the evidence has satisfied the element of the charge or claim. So that's really important. A review of the evidence trying to put the pieces together. Think about a conclusion. The same kind of thing. If you're trying to show that someone's guilty, you're putting all the pieces together for the jury, so they don't have to sort of figure it out themselves. Okay, and they're pointing out to the law when applicable. And they're asking for a favorable verdict for their side to win. The defense is doing the same thing, just the opposite. They're trying to show how the evidence does not satisfy the elements of the charge or claim. And they're looking for a favorable verdict for themselves as well. Okay, any questions there? Okay, I want you guys to take a minute, and you can stop it. And you're going